This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about why a plaintiff waited too long to sue an insurer who had accused him of fraud, and why the statute of limitations starts to accrue when the judgment against the insurer became final and he could start his lawsuit. Dr. Gerald Dworkin sued Liberty Mutual and various subsidiaries for wrongful use of civil proceedings arising out of a previous lawsuit accusing Dworkin of insurance fraud. Defendants moved to dismiss on the grounds that Dworkin's suit was barred by the statute of limitations. In Gerald Dworkin v. Liberty Mutual, a United States District Court for the Eastern District of Pennsylvania on September 18, 2024, resolved the insurer's motion. Dworkin was sued in 2017 by Liberty Mutual for alleged insurance fraud. The Philadelphia County Court of Common Pleas granted summary judgment in Dworkin's favor, and Liberty Mutual appealed to the Pennsylvania Superior Court, which affirmed in November 29, 2023, in an unpublished opinion. The Superior Court reissued its decision as a published opinion on February 1, 2022. Liberty Mutual never sought rehearing en banc nor leave to appeal to the Supreme Court of Pennsylvania, so on March 22, 2022, the Superior Court remanded the record to the Common Pleas Court. Dworkin filed his initial complaint in this case on March 20, 2024. That's 2 days before 2 years after the March 22, 2022 decision, and more than 2 years after the February 1, 2022 ruling that was final. A motion to dismiss under Rule 12b-6 tests whether the complaint alleges facts that make out a facially plausible claim. A court may only dismiss a claim under Rule 12b-6 based on the statute of limitations when the basis for the limitations defense is evident from the complaint itself or other materials the court may consider, which includes exhibits attached and to the complaint and matters of public record. The statute of limitations for a claim of wrongful use of civil proceedings is 2 years. A claim's limitation period generally begins to run as soon as it accrues, that is, as soon as the right to institute and maintain a suit arises. A plaintiff's right to institute and maintain a suit for wrongful use of civil proceedings generally arises when the underlying proceedings have terminated in his favor. Underlying proceedings in Pennsylvania terminate for the purposes of a wrongful use claim when the defendant in the underlying proceeding successfully defeats the plaintiff's attempts to have him held legally liable. The defendant successfully defeats the plaintiff when judgment for the defendant becomes final, which generally happens when the judgment has been upheld by the highest appellate court having jurisdiction over the case, and the judgment has not been appealed. Dworkin contended his claim accrued when the Superior Court remanded the record to the trial court. The effect of an action occurring after a judgment becomes final while remanding the record is only a ministerial task which cannot happen until after the Superior Court's ruling becomes final. Dworkin's claim accrued at the expiration of Liberty Mutual's time to appeal the Superior Court's ruling because that is the point at which he successfully defeated Liberty Mutual's attempts to have him held legally liable. In my opinion, the statute of limitations exists to protect defendants against the stale claims which are difficult to defend because facts and witnesses become stale and forget what happened. Dworkin beat Liberty Mutual's suit claiming he committed fraud. If he wished to obtain damages from Liberty, he should have sued as soon as he could, rather than waiting more than 2 years and claiming that his account only accrued when the ministerial act of sending the case back to the trial court, rather than on the day the final judgment was entered at the time of the appeal affirming his judgment. Of course, Mr. Dworkin is not without a relief. If his lawyers knew about all of the dates and filed late, then he may have a good case against his lawyers, but probably not. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog post, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,850 blog postings. You can also subscribe to these videos. They're free at rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. Thank you for your attention. And if you really would like to see additional detailed information about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication.